Hello folks, welcome back to the Wikipedia world, and I am Abhinay Gupta. And the topic under consideration for today's lecture would be the winding up, right? And we always need to remember that the provisions for this chapter will be contained in your Companies Act 1956 and not your Companies Act 2013, right? And in the previous lecture, we had already started the powers of the court in the case of winding up. Right? So if you have missed out the lecture, please go back to the previous lecture. Over there we have already discussed the powers of the court, which are bifurcated into two time zones. One is before the winding up order and the other is after the winding up order. So the portion of the powers of the court which is before passing the winding up order has already been covered in the previous lecture, right? And we have covered the four powers that falls after the winding up order also. Right? So today we'll continue with the remaining 8 powers of the court after the winding up order has been passed. Right? So if you talk about the powers of the court after making the winding up order, then we have already discussed the power to stay winding up, to settle the list of contributories, to transfer properties to the liquidator, and to pay debts due by contributories. And in today's lecture we'll move ahead with the power of the court to make calls, right, which is contained under section 470. So basically you know that when the winding up order is being passed, right, when the court has already decided that yes, the company needs to be wound up, what happens is the liquidator who is appointed for that company, for liquidating the company, the official liquidator needs funds to pay out the liabilities, right? So all the assets, as we have seen, get transferred to the liquidator, may it be from the contributory, the trustee, receiver, banker, agent, officer, employee, whosoever it is. They will all transfer all their properties to the liquidator, right? All the properties that belong to the company, not their private properties. Okay, so now when the liquidator has all the properties, the liquidator will try to dispense off with these properties, and the money that it gets from there, right, that will be used to pay off the liabilities, right? So before that, so that is one thing that will be done while winding up the company. But if there is a shortage of fund, if the liabilities are not being met by selling off or disposing of the assets of the company, then what? Then the court will order the contributories to make the payment of the due calls, the call for the shares that are still due with the contributories, right? So all the contributories, they'll make the balance payment of the call that is due by them, right, and that money will be used to pay off the other liabilities. And if after paying off the liabilities you have something surplus remaining, then it will again be distributed back to the contributories in the ratio, right, in the ratio of contribution, right? So the first thing we need to understand that the power to make call lies with the court only, and the court has the right to make the call on either all the contributories or any of the contributories. That depends on the court, right, from whom they want to make the call of the pending shares, right? So over here, one thing we need to understand is that the liquidator does not have the power to make the calls. They have the power to dispose of the assets of the company, but they do not have the power to make the calls. So if at any point of time they want to make a call, right, for the call money which is pending for the shares that have been issued, then they will have to take the liquidator will have to take the permission of the court, right, the court under which the jurisdiction of winding up is being taken place. Now consider an example, right? Mr. X was a contributory, right, and Mr. X was also a creditor for the company, right? Mr. X, for example, owed rupees 10,000 to the company, and somewhere within the accounting transaction even the company owed rupees 8,000 back to the contributory. So when the court makes the call for the shares, right, Mr. X pops up. He says, my lord, I owe rupees 10,000 to the company, but even the company owes me 8,000 back. So I'll do one thing, I'll deduct that 8,000 and pay you the balance 2,000, right, because ultimately that is gonna come to me. So I'll keep my share with myself. I have the documentary proof, I have all the details over here in the file. I'm submitting the file to you, and I will pay only rupees 2,000. What do you think? Will this petition be tenable? The answer is no. Because the act itself says that there will not be any knocking off. There will be no set off against any claim. Right? I mean, there no set off can be claimed against any call. Right? So, because why this happens basically is that when the liquidator makes the call, right, he takes the money from the contributories, and then that money is again attached to the common pool of fund, from where they are going to pay the contributories, their creditors, right, the people to whom they have a liability to pay something. So now when they have taken the money, they have already added the money in the pool of fund, they go on to make the payment on preference basis. First the employees and the workmen will be covered, and then the statutory dues and the other things, like they have a preference, the preference of the people who will be getting the money, right? So first of all, one segment will be cleared, and the second segment will be cleared, and if balance is remaining, then we'll come down to the third segment. Again, if we have surplus, we come down to the fourth segment, and that is how we proceed. And if we don't have money, the last segments, they suffer, they don't get any money, right? So that is why the contributor is not allowed to knock off, because the court is not sure, or nobody is sure where the contributor will lie in that list of preference. So there may be a possibility that the contributory do not get the 8,000 rupees back, because by the time that contributory was to appear in the list, the fund has already been exhausted, right? So it has been made a general rule that there will be no set off against the claim, or there will be no set off of any claim against the call, right? Now when the court is making the call, right, we said that yes, the court can make the call for either all the contributories or any of them. It's as it deems fit. Now, for example, if the court needs just 2 crore rupees more, right, and the total list of contributories, if they go on to contribute all the call money, then it adds up to rupees 10 crores. So the court can decide, right, who are the people who should be contributing over here for 2 crores, right? There's a procedure how it decides. We'll not get into it, that is not in our course right now. So we'll pay attention to the provision that has been given in the act and that we are concerned with, right? So the court will decide, but make sure that the court will not draw a line once it reaches 2 crore. It will call a surplus money. For example, 2.25 crore, 2.5 crore, 2.3 crore, something like that. The reason is there are many contributors who will default, who would not turn up, who would not pay the money, who would not contribute to the common pool of the company. So in that case, if the court just gives out the order to those contributories who sum up to rupees 2 crores, right, and then 50 lakh worth of shareholders, they do not turn up, what happens is again you don't have surplus fund, right? So it's always better to keep a buffer in that situation, right? So the court may make the call for such amount as it can cover up the surplus, right, the amount which would leave some surplus after everything is being paid, right? And finally, the court will adjust the right of all the contributories among themselves, and if there is any surplus remaining after paying off all the liabilities, then it would be returned back to the contributories, right? Now the liquidator, the official liquidator who has been assigned for the job in the company, right, he has some time duration within which he has to complete the liquidation, right? He cannot just go on and on with the liquidation for years and years. At times it may be taken on for a longer period of time. It is when the liquidator continues the company, the management leaves and the liquidator takes charge of the company and plans to continue the company for some more time, because it thinks that yeah, the company will be able to recover a lot of things, right? That is a separate situation. Again, we'll read it later in the chapter when we come to that point. Now what you need to understand is that okay, there is a time bound, not defined, not restricted, but yeah, the liquidator has to complete the liquidation within the reasonable time, right? So the creditors who have stood up in the line of the receivers, right, for the contribution that the contributories have bought in, they will have to prove their debt. It's not that okay, the company is being liquidated, Mr. XYZ, W, U, V, S, T, everybody comes up and they say, oh, the company owes me, the company owes me, the company owes me, please give me the money, give me the money, give me the money. No, even if people come up like that, the liquidator will need to prepare a list of that people, list of those people who would be the receiver in the case of liquidation, right? And now they will call for those people to prove give me the documentary proof that yes, if the company owes you some money, then give me the invoice that yes, you have supplied certain material to the company. Where is the stamp? Where is the acknowledgement? Right? So it will check all the documents, and the creditors will have to prove the exact amount that they want back from the company. Right? They will have to have all the invoices, all the bills, all the supportings, everything. Right? So the creditors have been allotted a time period. That okay, once you have been declared that yeah, you can come up for your demands that you have, but if you have a demand and we have taken it into consideration, now we want some proof, right? Without any documentary proof, we won't be able to give you the money. So the creditors would be allotted again a little time to arrange those documentary proofs. But if any creditor is not able to prove in time that yeah, the company owes him something, then he would not get that money. The liquidator would exclude him from the list of receivers, right? And that creditor would not get anything. So if you want your debts back from the company, you will have to prove it on time that yes, the company owes you, so that in the process of liquidation it is a smooth factor and the liquidator is able to actually recognize and pay off the liabilities, right? So the next power that the court has is to order costs. Now what do you mean by ordering cost? Now when the court has gone into the procedure of winding up the company, right, they have appointed the official liquidator. So there is a cost that is employed for winding up the company. The official liquidator needs to be paid. The other services taken from other agencies needs to be paid, right? There is a cost involved in winding up, the documentation cost and the other things, right? It goes on for months, like 6 to 10 months. That is the time that winding up takes. So during that time there are certain costs that will be incurred, right? So at the point of time when the court starts to realize, or the liquidator starts to realize that okay, yeah, the funds are being pulled out, drained out, right? The funds that we have collected from the contributories and from by disposing the assets and stuff are being drained out to pay out the liabilities, and as per the projection we will not be able to meet all the liabilities. So in that case, what will the court do? Court will say, okay, anyways you're not able to meet all the liabilities, let us do one thing, please keep this amount of money aside, because that will be needed for our expenditure of this winding up, right? Otherwise winding up would be a loss situation for the court. So the court will not want it, right? So they'll say that if there is winding up going on, then from that pool of fund, please exclude the relevant amount that will be needed for the further expenditures of winding up, right? And after that, if there is something remaining in the pool, please distribute it off. I mean, if there will not be anything remaining, because at this point of time when we are pulling out funds for the cost, that is just because we know that the funds would not be sufficient to meet the liabilities, right? So at the end, when the funds are coming closer to the nil amount, so before that, when they are at the appropriate amount that you need for your cost, you put a stop on the distribution part and pull that money out for the cost of winding up and dissolution, right? And the next power that the court would have is the power to summon a person, right? Now whom would the court summon? So this power is contained under section 477 of the act, right? So basically, if we talk about the people whom the court can summon, then the court can summon any officer of the company, right? The court can summon a person who is known, right, or who is suspected to have the possession of any property of the company, right? That may be any books, any paper, any other property of the company, right? If they have it, it is in their custody, then the court can summon that person and ask him to please get those properties, get those books, get those papers out to the liquidator, right? Because earlier also they have made a call that all the properties that vest with any other person, and the property, if it relates to the company, that should be transferred to the liquidator, right? And so even after that, if some person does not do it, then the court can summon that person, right? The court can also summon those persons who are indebted to the company, right? So for example, the debtors are indebted to the company, they have to pay some amount to the company, right? But when the liquidator were realizing the assets, some of the debtors they denied, right? There are some or the other reason they did not turn up, they did not pay, so the court can summon those persons, right? Because they are indebted to the company, and even people who are suspected to be indebted to the company can be summoned, right? And the last category of the people whom the court would summon is those people who are or who attain that capability of giving information to the company, to the liquidator, right? Information about what? Information containing the facts about the promotion or the formation of the company, the old days, right? The promoters of the company, or any person who can give that information about the promotion, formation, the trade, the dealing, the properties, the books, the papers, the affairs of the company, and everything. Like they will generally be a part of the management of the company, right? So who are the four categories of people whom the court can summon? One is any officer of the company. Two, any person who holds any property of the company. Three, any person who is indebted to the company. And four, the senior management, right? The people who are capable of giving the information that is needed by the liquidator, right? And the court may examine any officer or any person who has been summoned, right? The four categories that we have seen, they can at any time, any point of time be summoned. They can be examined on oath, right? And then when he has been examined on oath, the court will require him to please come and produce or give it to the liquidator all the books, all the papers, the documents, the records, whatever you have that pertains to the company. If you have any information that pertains to the company, please hand it over to the liquidator, right? And when the person is summoned, when the person is examined on oath, and then the person admits that yes, I am indebted to the company, this is the amount that I owe to the company, right? So if you have been proved guilty of that, or if you have, it's not being guilty, if you have been proved to hold any property or indebtedness to the company, then you will be supposed to make that payment. So the court will ask that person to make the payment, right? The payment of the amount with which they are indebted to the company, right? And again, on authorization on oath, they came up with a fact that okay, one of the officer, right, he held one of the houses of the company, the property, the fixed asset of the company, because he was dwelling in it and he still holds it. So the court will again go back to him. Listen, that property belongs to the company. Please give it back to the company, because if that's a building, right, even if it's a duplex, it will sell for a good amount, and that will be used to set off the creditors of the company, right? But if any of the person who is supposed to be summoned by the court, if they fail to appear in front of the court, right, and that too without any valid reason, then the court may cause him to apprehend the examination, right? So he will be apprehended and he will be brought before the court for examination, right? Now if we move on to the next power of the court, then we have public examination of promoters and directors, right? Now the promoters and directors, these are the people who are basically involved in the formation of the company and the regular day-to-day running of the company, right? The promoters are basically involved in the formation, and the directors in the day-to-day maintenance, right? Now if the liquidator, by its investigation or by the procedures that it is following, if it comes across a fact, right, which proves that the promoter or the director, they have attempted a fraud in the company, right, then in order to make it clear, in order to get the information out of it, they can at any point of time publicly examine those promoters or the directors who are suspected with that fraud, right? And this power is given to the court by section 478. So there is any promoter, any director on which the liquidator has a suspect after gaining certain information that yes, there is a possibility of fraud by this person, so that person will be examined publicly, right? The next power that we have is arrest, absconding, contributory. So why has this power been extended? As we already discussed earlier, right, that when the court is ordering the contributors to bring in the call money, right, it will always order the call money with a surplus, with a margin. Like if they want rupees 2 crore to set off the liability, he may ask for rupees 2.4 crores, right? Because there are certain contributories who would not turn up, who would basically uh, who would feel or who would be tempted to flee, right? And some of them would be beyond the control of the court. So court cannot go behind those people and just investigate, because at this time the priority is the liquidation. Those people will be tackled later. So the court needs to be prepared that okay, if the funds are coming in and there are some people who are not bringing in the fund, who have turned their back, right? So we should have surplus amount called for so that we can at least meet the requirement. Now over here, when we are talking about the arrest absconding contributory, means if there is any contributory who is trying to flee, right? Or if the court has from somewhere found an evidence that there is a probability, right, or there is a belief that this contributory is supposed to leave the country, the contributory is planning to abscond or to conceal the property that it has, the property that is belonging to the company, right? Or if the call money is due from that contributory, the contributory is trying to evade that money, right? It is trying to avoid the examination, right? Then the only way to keep these kind of contributories in control is to arrest them. So the court will order an immediate arrest of that contributory. Please arrest that contributory. I don't want him to flee or to be fled out of the country, right? Because by that it will basically be out of the jurisdiction of the court unless and until it comes back to the country. So the court will order the liquidator to please arrange for the arrest of that person. That person will be under the custody, right? By that time they are trying to recover all that he had, maybe the call money, the property that it was trying to evade, and everything, right? And although this person is inside, there are many manipulations that can be done in the back end, right? Like if that person has some more secretary, or if that person is a big shot and running a company or something, he has some legal lawyers, the assistant and everything. So what will he do is, although he is inside the jail, he will get everything sorted outside. So if there are certain books and papers that the court needed or the company needed, he may get them hidden. If there are certain properties, he may have already arranged to excuse those properties out of the court or out of the hands of the liquidator. That is why it is important that if that person has any movable property, that should be seized. If that person is having the custody of any of the document, any of the papers, right, then those papers and documents needs to be seized, so that there is no risk of that person fleeing away, right? So these are basically the powers during the winding up of the company, when the liquidator is working, when the liquidator's task is under progress, right? Now when the liquidator's task come to an end, then what? Then the journey of liquidation will also come to an end, right? And then they reach the destination, which is the dissolution of the company. So the court has the power to order dissolution of the company, but what is the appropriate time? When should the court make this order? So number one is, if the liquidator has performed all its tasks and beautifully he has been successful at winding up the company. So if the processes are done, everything is completed, formalized, formatted, then that is the time when the court will order the dissolution of the company, because the company now is completely wound up, right? Or there can be a situation where the court will consider any of the two conditions before ordering winding up. One, that the liquidator is not able to commence, not able to move ahead, right? There's a deadlock or there's a block, that now either there are no surplus funds or there are some other restrictions and the liquidator is not able to continue with the winding up proceeding. So once it is confirmed that yes, the winding up cannot be made, right, either for want of funds or the assets, right, or for any other reason whatsoever. But if it is concluded that yes, even if we give the liquidator time, the case is not moving anyway ahead, then the court will directly order for dissolution of the company, right? Or otherwise also there is another ground that is left open, that if there is just and reasonable situation, or they feel that it is just and reasonable in the circumstance, right, of that case, then the order of dissolution of the company should be made by the court, right? Got the point? So when you're talking about dissolution, it is either when the company has been wound up, or they know that the company cannot be wound up, right? Or if there is any other that you know the company can be wound up, it is not yet wounded up, but still there are some other just and equitable ground on the basis of which you think that you should wind up the company. Then the court will order dissolution straightforward. Right? And at last we have that the court can declare the dissolution void. So the power of the court to declare the dissolution void. This is contained under section 559. So since the dissolution has been ordered by the court, right, so the court will also have the power to revive the company. Because there may be a situation that, okay, because of the situation that existed on that particular day, the company needed to be wound up. So the winding up proceedings went ahead and the company was completely wound up. And once the company is wound up, the company was also dissolved by the court. But then again the court thinks, or on application, it has been proved that the company wants to be revived. And they are now in a very good position and a better position and can continue with the work. So the employees who had been retrenched, who have been kicked out of their job, the suppliers who lost their customer, and the distributors who lost their supplier, the people who lost the product in the market, the laborers who lost their job. So everybody, right, who was connected to that company, who suffered because of that winding up or that dissolution, right, now they can again gain back what they lost. So with that view, the company may again be revived. Now how is the company revived once it has been dissolved? So if it has been dissolved and it wants to be revived, then the court will have to pass an order. Right? The court can declare that dissolution void. So the situation will go back to the same scenario where it was. That means the company will be functional as if it was not ever dissolved. Right? And this provision is contained under section 599. And if at any point of time the court gives out this order that the declaration of dissolution is void, then that means that it is void ab initio. And when it is declared void ab initio, that means whatever proceedings or whatever facts have taken place due to that dissolution after the date of dissolution, they will all be void now. Right? So if there is any consequence that which appeared or which popped up as a result of the dissolution, that would be kicked out. Right? Those consequences can be avoided now. And if there is any proceeding that has taken place during the interval, right? If I talk about the interval, it is between the date of dissolution and the date of the order for revival of the company, or the order for setting aside the declaration of the dissolution. Right? So those proceedings, they will be set aside and everything will be back to square one from where we started. Right? So these are basically the powers of the court. If we go back, we have 5 powers over here and 7 powers over here. There is all total of 12 powers of the court. So before winding up with this lecture, let us just go through what are the powers of the court. So first of all, the court has the power to stay the winding up. And that will be done when there is an application received by the court. Right? Second, it will settle the list of the contributories and the application of the asset. That who are the people who needs to bring in the money to the company and what are the assets that the company had that can be disposed of. Right? And then it will order all the people like the contributories, trustees, receiver, banker, agent, officer or employees of the company to bring all those things that they have which is connected to the company to the liquidator. They are supposed to transfer everything to the liquidator. Right? And if there are any debts that is due to the company by any contributory, even they will be called up by the court. Right? And the court has the power to make the call. That power does not vest with the liquidator. Rest all the powers for winding up vest with the liquidator, but over here the liquidator will have to take the permission from the court. Right? And then again the court will decide how much to call with the surplus and everything, right? And how to adjust the right of the contributory. The contributories are not able to adjust if they are also owed something by the company, right? Then we have the power to exclude the creditors who do not prove on time as to what they owe or as to what they are owed by the company, right? The court can also order the power, court also has the power to order the cost of winding up. So if there is insufficient fund, then the court can order that, okay, let's pull out these amount of fund because that will be needed for winding up, and if there are anything else remaining, please distribute it. but these funds are required to be locked for the purpose of the expenditure of liquidation. Right? Then we have the power to summon a person who is suspected of having a property of the company. So there are four people we have discussed. It is any officer of the company, the person who has the position of a property of the company, the person who is indebted to the company, or the person who is capable of giving the information which is required by the court or the liquidator. Right? The court may also examine him on oath and everything that we have seen. That thing starts over here. Next is the power to order the public examination of the promoter and the director. That is when they are supposed to, or they are found to be guilty of fraud. Right? Then we have the power to arrest the absconding contributory. So if the court feels that no, one of the contributory or some of the contributory, they're trying to flee away from the country, right, or they are trying to hide themselves or hide the property or try to manipulate something so that they are not supposed to contribute, right, then the court will certainly order arrest of that person. That person will be arrested and kept behind the bars, and all his movable properties will also be taken under custody. All his documents, papers, everything will be seized, so that he is not able to manipulate anything for the time being, right? And when the proceedings are done, then he may be released, right? And then there will be the dissolution of the company at last. That will be after either the company has been wound up, or the court knows that it cannot be wound up due to some certain reason, or if there is any other just and equitable ground, right? And at last, even that dissolution can be revived. The company can be revived at any point of time, and the dissolution would be considered to be void ab initio. So that is all about the powers of the court after making the winding up order. And with this, we would be concluding our class today, right? And we'll be continuing with the provisions of the next section. That is, next we'll pick up the topic of the consequences of the winding up order, right? Like the communication of the winding up order, the copy of winding up order to be filed with registrar and stuff. Those procedures, we'll take it up in the next lecture. So until then, this is Abhinay Gupta signing off. Thank you and bye-bye.